Welcome back to the Making International Law in Korea, the video series. In this video, I'll be explaining to you about Korea's attitude toward peaceful settlements of international disputes. The obligation to settle international disputes by peaceful means, as stipulated in Article 2.3 of the UN Charter, is deemed to be an established norm of customary international law. Korea has neither been in breach of this obligation nor actively engaged in dispute settlement mechanisms available under Article 33 of the UN Charter. While said Article 33 enumerates the primary avenues for the peaceful settlements of international dispute, such as negotiation, inquiry, mediation, conciliation, arbitration, and judicial settlements, resort to regional agencies or arrangements or other peaceful means of the member states' own choice as a means of the resolving international disputes, Korea has seldom triggered any other means except for negotiation and the double-tier dispute settlement mechanism when attempting to settle international disputes. Korea has not employed non-judicial means of dispute settlement, such as inquiry, mediation, or conciliation. The only bilateral agreement concluded for the very purpose of dispute settlement is that exchange of notes concerning the settlement dispute concluded between Korea and Japan in 1965. This exchange note provides that any dispute between parties, unless otherwise agreed, will be resolved primarily through diplomatic channels. If a dispute cannot be settled by the diplomatic means, it should then be referred to conciliation by a procedure agreed upon by the parties. As of recently, Korea has yet to invoke this conciliation procedure to reach settlement. With regard to arbitration, Korea has never joined an arbitral proceeding. Article 3 of the agreement on the settlement of problems concerning property and claims in the economic cooperation concluded between Korea and Japan in 1965 refers to diplomatic channels as a principal means of attempting to settle disputes arising out of the interpretation or implementation of the agreement. However, any disputes which cannot be settled through such diplomatic means must be referred to arbitration. A decision concerning this agreement was rendered by the Korean Constitutional Court on August 30, 2011, regarding the issue of comfort women, when the court recognized inter alia that the positive obligation requiring the Korean government to ensure the dispute settlement procedures as provided in Article 3 of the said agreement. As to adjudication as a means of dispute settlement, Korea has not recognized the compulsory jurisdiction of the International Court of Justice under Article 36, paragraph 2 of the statute of the court. However, Korea has accepted the compulsory jurisdiction of the ICJ for disputes arising out of the interpretation or application of the optional protocol to the Vienna Convention on Diplomatic Relations concerning the compulsory settlement of disputes, as well as the optional protocol to the Vienna Convention on Consular Relations concerning the compulsory settlement of disputes. Korea, as a party to the United Nations Convention on the Law of the Sea, UNCLOS, has not submitted any written declaration to select a means of dispute settlement as specified in Article 287 of the UNCLOS. On Article 18, 2.6, Korea submits a declaration in accordance with Paragraph 1 of the Article 298 of the UNCLOS, where Korea expressed that it would not accept compulsory dispute settlements involving maritime delimitation, military activities, law enforcement activities on maritime scientific research, or fisheries, and all disputes in respect of which the UN Security Council is exercising its functions mandated by the UN Charter. In sum, Korea has recently employed different means for the settlement of international disputes, though it has been an active participant of the WTO dispute settlement. One of the possible explanations for Korea's rather confined choice for dispute settlement is that most issues at stake are delicately they relate to territorial matters, which can never be easily left for third-party decision. Moreover, Korea's legal culture and tradition, as with other East Asian countries, prepares non-binding procedures as opposed to adversarial the means of the settlement. Before 1948, Korea did not have a chance to contribute to the development of international law. At the time, the European-oriented international law began to regulate interstate relationship of East Asian nations which accepted international law. Western international scholars questioned whether Korea was a member of international community as a sovereign state, or other scholars did not recognize other East Asian countries aside from Japan as subject of international law, such as Korea, China, and Siam. Korea could not contribute to the development of international law under such circumstances, especially when the nation went under the colonial rule of Japan as soon as it opened its door to the West, resulting to the Japanese annexation. Upon gaining independence from Japan on August 15, 1945, Korea was finally placed in a position where it could contribute to the development of international law. However, due to how the armed conflicts between two Koreas destroyed most of the economic system in the country, Korea experienced a hardship which prevented it from participating in any meaningful activity to contribute toward the development of international law. Under this difficulty, however, a noticeable Korean state practice in terms of the developing international law emerged, namely, the declaration by the President on sovereignty of adjacent ocean, which is so-called Peace Line Declaration. This declaration states that Korea has sovereignty over all the natural resources, minerals, as well as marine products within a certain distance of water, including ocean floors and the continental shelf near the Korean peninsula. The declaration also allocated maritime sovereignty to Korea far beyond internationally recognized territorial limits. According to the order of international at the time, the unilateral declarations and measures by Korea could be understood as violation of international law by infringing right of fisheries in international waters. Korea's such measure, however, can be viewed as pioneering and taking the lead to the change of the maritime law, influenced by the United States President's Continental Shelf Declaration and High Seas Fisheries Declaration, and Latin America's countries' contention on the expansion of the oceanic jurisdiction. In the United Nations Law of the Sea Conference in Geneva in 1958, Korea, based on the proposal of the said declaration, took a position emphasizing the special interests on fisheries of the coastal states adjacent in international waters and stood against those countries that propose freedom of fishing on the high seas. The Peace Line Declaration expanded the notion of exclusive fisheries zone to Asian region and subsequently contributed to establishment of exclusive economic zone. However, quite interestingly, Korea's contention of sovereignty over the continental shelf was not accepted by the international community at that time. Armed conflict in Korea in the early 1950s also affected the development of international law. For example, the United Nations, with the absence of the Soviet Union, has jointly identified North Korea as an aggressor and implemented a resolution under the UN Security Council to prove assistance to South Korea. Due to the absence of Soviet Union, the legal effect of the resolution was questioned based on the interpretation of Article 27 of the UN Charter. Since then, the United Nations has held that an absence or abstention of a permanent member of the UN Security Council does not have an effect on the approval of the resolution by the UN Security Council. The UN General Assembly adopted a resolution of uniting for peace in order to avoid the Soviet veto against the resolution as a response to armed conflict in the Korean Peninsula. So on this resolution, the special session of the General Assembly called Special Emergency Session was formed, and the interim committee established in 1947 became meaningless. After the armistice agreement was concluded and repatriation of the prisoners of war became an issue, and the concerned parties handled this matter in a way that respect the individual wishes of each prisoner of war. Such a practice led to the insertion of Article 118 of the Vienna Geneva Convention relative to the treatment of prisoners of war, which prescribes that prisoners of war shall be released and repatriated without delay after the cessation of active hostility, which does not include the forced repatriation of prisoners of war who do not wish to send back to their country. The Korea-Japan Agreement of the Joint Southern Continental Shelf Development of 1974 was influenced by the 1969 decision of the International Court of Justice on North Sea Continental Shelf cases that perceived the continental shelf as an extension of the dry land, which enabled Korea-Japan to jointly explore and develop natural resources and surrounding waters where the claims of sovereignty between Korea and Japan has been overlapped. This agreement has been viewed as one of the most important attempts of a joint development by putting an end to an issue of sovereignty over disputed waters. This initiative was also a key example that contributed to the development of international law by creating an international model on a joint development in the continental shelf as a first example which drove the consensus on the joint development based on the recommendation of the International Court of Justice decision in 1969. Furthermore, this agreement is also viewed as putting a great significance on the development of maritime law by setting a precedent of the implementation of the obligation to negotiate under general international law and a precedent of implementation of negotiation duties under Article 83(3) under the United Nations Convention on the Law of the Sea, UNCLOS. Other than this, the agreement was a model of taking tentative measure on the same article and being a model for duty of cooperation under Article 123 of the UNCLOS. As a full-fledged member of the international community, Korea gave more statements and activities in meetings and forums related to international law, and Korea's contribution to the development of international law became a common practice. To give a couple of examples, during the meeting in Rome for establishment of the International Criminal Court, ICC, there were conflicting views as to the system of acceptance of the ICC jurisdiction. One view was the adopted method based on state consent, and the other view was to recognize automatic jurisdiction as the big crimes that fall under the universal jurisdiction. Amid this controversy, Korea suggested a proposal that one or more of the countries from country of origin of crimes, country of detention, country of defendant's nationality, and country of plaintiff nationality that are state parties to regulation of international criminal courts or accept the ICC jurisdiction, the jurisdiction of the case be recognized. Unfortunately, this proposal was not accepted in the ICC statute, but was supported by many countries with an appraisal of an excellent compromise and evaluate as a contributing to a final agreement to jurisdiction. Another example is that during the negotiation process of the amending 205 protocol to the Convention of the Suppression of Unlawful Acts against the Safety of Maritime Navigation, so-called the SUA Convention, the Korea contributed to making amended SUA Convention in line with the existing order under the international law of the sea. In particular, Korea has been appraised to draw a compromise of inserting to the final protocol, understanding that the definition of related material contained in the UN Security Council resolution of year 2004 can be used in relation to meaning of dual-use material. Other than this, it has been also pointed out that Korea has contributed through civil organizations and the victims themselves to save victims' military sexual slaves, to raising the public awareness in the international community that sexual violence during the war is an intolerable crime as a massacre of prisoners of war or torture.